Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr law firm. And I'm your host, Alan Kaplinsky, the former practice group leader for 25 years and now Senior Counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be talking about today or anything else in the world of consumer financial services, please don't forget about our blog, consumerfinancemonitor.com. We've hosted our blog since 2011 when the CFPB became operational. There's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you access your podcasts. And also, please let us know if you have ideas for any other topic that we should consider covering on a future podcast show or speakers that we should consider as guests on our show.
Today's episode is part 2 of a 2-part series featuring a repurposed webinar we presented on May 12th entitled Coerced Debt, New York's Law and Emerging Trends Nationwide. If you haven't already done so, be sure to listen to part 1 of the series, which we released last week on June 11th. Today, we are joined by Angela Litwin, Divya Subramaniam, Carla Sanchez-Adams, Naomi Young, and Dan Wilkinson. These distinguished speakers will share their insights on how the law compares to developments in other states, and from the perspective of creditors, servicers, and debt collectors, the most significant implications of the New York law. With that, I'm pleased to turn it over to Naomi Young to begin our discussion of the challenges survivors face in asserting debt-related claims.
Yeah, something I say often about the populations we work, we are legal services organizations and we represent low-income people for free. And when you're working with people that live in poverty and survivors, they're never single-issue clients. They're always coming in with a multitude of things that they're dealing with, and the legal problem I may be assisting with is just one element of what they have to work through and overcome, especially as they're coming out of an abusive situation or at times still in it. And there's often not like a bright line of like, and now I'm done with this situation. It's a recovery process. So I think one thing that's important to note is that any survivors who are going to assert claims under this law are going to be a relatively small subset of the people who have actually suffered coerced debt. And we know that because we know that people underreport abuse across the spectrum of abuse that we know. We also know that tiny portion of people that are experiencing these issues are going to be able to obtain legal counsel in New York. Only a tiny percentage of people are represented at all in consumer debt cases. 98% are not. And so many people are going to be unable or unwilling to endure a potentially lengthy legal process that requires them to relive trauma. And I think that's also important to understand. Like, for someone to get to the point where they're making a claim, they've already overcome a lot. They have processed trauma to the point that they can describe what happened to them as abuse. They are willing to name a debt as as something that occurred because of that abuse. And they are willing to tell their story to strangers in a multitude of ways. They're willing to go out there and talk to other strangers like law enforcement agents to get the appropriate documentation. And so we work with survivors who have to overcome quite a lot to do all of those things. That would include folks that don't speak English as a first language or at all, people who are so impoverished that paying for the bus is a huge obstacle. I currently have a client like that, someone who has been in 3 different shelters in the past year because of the abuse, is probably going to become homeless again very shortly as a housing grant runs out. And so that's another thing that we see with clients is that they're incredibly transient because of their very vulnerable situation. And as Divya mentioned, it's important that they keep their address confidential a lot of the times because they're literally on the run from someone who has harmed them and is willing and ready to continue to harm them. And that's a really challenging thing to keep secret when you are making disputes about something that's on your credit report and difficult to do on your own. The cost of postage, the cost of transportation, the time it takes to be making phone calls when you're a mom, when you are trying to hold down a job, when you are just trying to find housing, it can be incredibly overwhelming. And so again, the people that are actually going to be making these claims, small number of the people that are actually suffering from the issue and have to overcome a lot to do that. So anybody that I'm working with is already done a lot to be there, and then I have to consider all the ways to sort of meet them where they're at and make sure that they get the recourse that they deserve.
Yeah. So,
I'll also add,
yeah, you go ahead.
let's even add that, right, in our study, we had people from a variety of socioeconomic backgrounds, and very few of them brought up coerced debt in their divorces. And people were more satisfied with the outcome when they did not bring it up than when they did, right? So even without the class barriers, you can have tremendous problem resistance to bring it up and good reasons for it.
Yeah. Yeah.
100.
Uh,
And I will
do-
also usually people are dealing with multiple legal issues. If they are, coming to us for help, it's often because they've consulted with a family law attorney and so may also be involved in family law cases as well. And it's a lot to handle.
So, Naomi, do you anticipate looking at the New York law? I know you haven't had, it's not effective yet, so haven't had any experience in practicing under it, but do you anticipate any unintended consequences or any gaps in the law from what from your perspective?
Yeah, I think one thing that for the large coalition of advocates that worked for years, we've worked through 3 legislative sessions in New York on this bill. The one thing that really stood out is the effective date being changed to 180 days from when the governor signed it, which was in March. So the effective date is now September 14th, and it's not retroactive. So essentially what that means for all of the lawyers and social workers and domestic violence shelters and folks that right now see people with these issues whose lives are completely altered and derailed because of coerced debt, we will not be able to provide help with this law. We will not be able to use this law to help any of those people that we have met up until, whatever point after September 14th, those debts that they realize. I think the other thing to note there is that people often don't learn about a coerced debt until long after it's could be arguably incurred. And that's the nature of the abuse. That's the nature of a family where one person is in control of the family finances. You're not aware of all of the debts that are being incurred in your name until you are having your wages garnished or your bank account frozen, for instance. So I think it may be a while before we see people realizing the hugely impactful potential of this law. And then, the other thing that I think this is a very strong law. I'm really excited to use it. But the thing that I am also expecting to be not necessarily an unintended consequence, but certainly a predictable consequence is that we know how disputes go in the identity theft context. We know that when our clients, with our help, with us drafting a dispute and sending it in exactly the manner that the credit reporting agencies are supposed to receive it and the furnishers are supposed to receive it, that nothing happens. They will not be relieved from that debt in that dispute process. And so, well, this law was very much drafted with the intent that nobody ever had to go to court. The courts would not have to deal with litigation. Fully expect that our clients will not necessarily see relief because of the notice provisions in this law that allow them to simply tell with rigorous documentation a creditor that a debt was coerced and sort of put their whole life out on the line there and say this is what happened, and then have that be returned to them as verified, totally accurate, uncontested, verifiable debt that you are responsible for. We'll see you in court when you bring the affirmative defense.
Well,
And
that
I
was,
know you want to say, I know you want to say something on this, Alan, but the other point, like unintended consequence, which is unfortunate, but there's not really much you can do on the state level, is even when that debt has been, discharged, so to speak, or when they've determined that it's not collectible, there's still the cancellation of debt income. There's 1099-Cs that go out, and it's still a problem for survivors. And there's already many other states that have passed these laws, and we've seen that in those other states where they still get issued a 1099-C. It's counted as cancellation of debt income for purposes of their tax returns, and then they have to challenge that, and that is incredibly difficult and needs the expertise, either like sometimes not even a VITA site, but a low-income tax clinic.
wow. Yeah, I hadn't thought of that, but you're right. Cancellation of a debt, a bona fide debt, is considered income. And it's what you call adding insult to injury, right? Have to go through the entire process of getting the debt canceled, and then you get a notice from the IRS that you've had income that you didn't report. Well, that was a very practical and insightful discussion on how the statute's expected to operate in the real world. I want to now broaden the lens and examine how coerced debt is being addressed under existing law and in legislatures across the country. Now, we only have about 25 minutes left. Maybe we'll go 5 minutes over, but I'd like to do, Carla, and you're next up, is we'll try to limit your segment to about 20 minutes to allow 10 minutes for Dan to talk about it from an industry perspective. So, Carla, you have been deeply involved in the advocacy and policy development in this area, at both the state and national levels. So you're really positioned well to understand the broader legal landscape and describe it. So how does this New York law compare to what we're seeing in other states? I mean, New York is a first,
So Maine was the very first state that passed something in 2019, and it's a much broader law. And there were two in the bill. There was the debt collection law as well as their credit reporting law. Their credit reporting law right now is in litigation preemption challenges.
Yep.
But it's very broad because it covers economic abuse and not just coerced debt. And it essentially says if you provide these documents, stop collection, full stop. No investigation, no back and forth. It's just no more collection. California, Texas also in 2019 passed a law. Then, as Angie mentioned earlier, we passed a law in 2021 and then again in 2025 that would include coercion under our definition of identity theft here in Texas. And then survivors can utilize our identity theft statute as well as federal laws that deal with identity theft to get relief. California passed a law in 2022, I believe, and became effective in 2023, if I'm not mistaken. And it creates a whole disputing process as well. There's affirmative defenses. You can bring suit to get deck action. You can get attorney's fees and statutory damages. Minnesota has a law. Connecticut has a law. Nevada has a law. Vermont just passed a law with non-government signature. I'm sure that I'm Miss Illinois has a law, and a lot of these are more recent. Like, if we're talking from Connecticut, 2025, I believe. Nevada was in 2025. Illinois was in 2025. So a lot of them have become effective this year. And, Vermont obviously this year, but Vermont's won't be effective until 2028. So there's 8 with Vermont, 9 states that have already passed legislation on this. And then to your point, there are many states that have introduced legislation. So Colorado introduced legislation 2 years ago. It stalled. It has not gone forward. Kansas and Maryland introduced legislation this session. They are now in reconsideration and a negotiation to bring back next session. Pennsylvania, New Jersey, Massachusetts are all kind of in different stages. I believe I'll have to double check if it was North or South Carolina. One of the Carolinas has introduced and kind of North. So, and then there's other states that have tried to address it outside of debt collection laws, but in like family law or housing. And so, places like Florida, Delaware. So it's popping up all over the place. And, New York is, because it's New York, there's a lot of banks and financial institutions there. It certainly is very weighty. But there have been other states that have also, California is another big one where there's a lot of fintechs. So yeah, it's a growing movement.
It's a lot more than I thought. I thought it was much more limited than that. But so that it makes it, I guess, even more, since the laws are not identical. There's no uniform statute here. And so there are differences from statute to statute, which makes it more complicated.
And especially because I like, not to interrupt, but some of them only cover debt collectors. Some of them cover both original creditors and debt collectors. Connecticut, for example, only covers credit card debt. Others cover all debt, but not secured debt. Some cover secured debt, but like allow you to repossess the collateral and not collect on the deficiency. And so there's like nuances in each of them. And some you can only bring an affirmative defense. Some you can bring a proactive suit. It's either a declaratory judgment type of deck action type of suit. So yeah, they're all very different. And we keep track of all of them, but you definitely do have to read the laws.
We could have done an all-day program on this, it sounds like. But let me ask you this. Let's put aside the specific statutes that deal with coerced debt and talk. Let's first focus federally. Are there any federal statutes that are really helpful? There's nothing federally like what you have in New York, of course, that wipes out the debt. But you talked about identity theft, and of course, you got the Fair Credit Reporting Act and Truth in Lending Act and a whole bunch of consumer protection laws. Are any of them helpful?
Absolutely. I mean, like I said, I was a legal aid lawyer for 13 years, and I represented survivors in many of these suits, like TILA with the Truth in Lending Act unauthorized use provision, or the Fair Credit Billing Act, part of TILA. But the FCRA, so the biggest one is using the FCRA to get a block or even just to dispute and remove the negative information. And that includes also a big piece is like security and safety. So getting addresses that don't belong to the survivor, email addresses, phone numbers, all of those things that don't belong to survivor but belong to the abuser off of the credit record so that they're not utilized by future creditors, security freezes. So there's a lot of things that you can do to help prevent future identity theft and coercion. But the strength of that statute really lies with identity theft. And so there's that piece of coercion where if a survivor in a state outside of Texas, so if you were in Nevada, let's say, well, Nevada now has a law, but let's say Louisiana, if you didn't have protections under that state and it was all coerced debt, you could still dispute it. And you could still show, for example, a protective order or a court order from a divorce, or, a SAPSR, which is like a, suit affecting the parent-child relationship. Right. You could use those to persuade the furnisher that it shouldn't be on your report because it's not a true picture of your your debt portfolio, right? Like you shouldn't have to pay this, you're not paying it. But it's kind of subject to the discretion of that furnisher after that reinvestigation. The block is easier because obviously it's like they shall block it if these things are provided. But even then, we, as one of the materials that we provided for this webinar, we have a study that we put out, or a report we put out after a survey where people were identity theft victims under the way that it's defined under the FCRA and were victims of coerced debt, tried to use the block and still never got it, or tried to dispute it and still never got it removed. And so there are for sure barriers that exist. And so, as everybody mentioned earlier in this call, if you are one of the few people who get an attorney, and even that attorney, one of the few people who helps you dispute it, you still have barriers to getting that relief. And then you have to file that lawsuit. And, I'll just say one of the last clients I had before I transitioned to NCLC, I had her for 5 years trying to fix coerced debt. And in her case, all of the debt that we were disputing was without her knowledge or permission. She never knew about it. And so we disputed it. She had like 2 lawsuits that we had to defend and file counterclaims. And then we had to sue all 3 CRAs as well as a furnisher. And all of that took 5 years to fix it all and to get her the relief that she should have gotten from the get-go. So there are federal laws, there are gaps in those federal laws, but the real tension lies in the liability piece. So even if you can fix the credit reporting piece, it doesn't necessarily have any bearing on collection and liability.
Yeah.
And that is difficult to do at the federal level, even though there are some efforts underway, specifically with agencies that represent survivors of trafficking. There are conversations about extending protections under the FDCPA for survivors of trafficking and economic abuse. But you cannot, at the federal level, you can't dictate what state courts do, and you can't dictate state contract law. So that's why really the best way to address it is through state law, or state debt collection law.
Right. So tell us, I know you were involved in a petition for rulemaking related to coerced debt that was filed in 2024 before the CFPB, when it was under different ownership, so to speak. Different director, Rohit Chopra at that time, different administration. Tell us, we don't have a lot of time, but tell us a little bit about what you were trying to achieve there.
Sure. So if you look at the FCRA in, the definitions for what's considered identity theft, it specifically says identity theft is defined as, and then there's the last piece that says, or as further defined by the Bureau. An identity theft report says defined as, or as specified or further defined by the Bureau. So they have the authority given to it by the FCRA to issue further regulations clarifying what those definitions are. So our petition for rulemaking was that they would do rulemaking under Reg V to be able to expand those definitions to include the concept of effective consent. So similar to what was done in Texas, what we did here by just utilizing a definition that was already in our penal code for something called credit card abuse, where it said, consent is not effective if it's given under duress or force or threat of harm. And so that was the suggestion, is expand it that way. And then by expanding that definition that way, then also expand what's considered an identity theft report. And one of the things that we really tried to do is to mimic what, NCLC, we wrote a model law on coerced debt that states who are thinking of passing this law can utilize as just a starting point. And so we did list a lot of these types of documentations that New York utilized. And they, also, I'm not saying that they copied us, they also utilized it. Some other states have also utilized some that list the different types of documentation that could be sufficient to prove that somebody is a victim of coerced debt or identity theft, because of the barriers that exist to getting a police report, to getting, that FTC report that unfortunately nobody, like, you submit it and the comments say it should be sufficient, but nobody pays attention to it, which is unfortunate. So we, it's expand it from those things to also include other types of certification and documentation to support somebody's claim of identity theft. And then there was one last piece, which I think is like really interesting for you legal, like in the weeds legal people, is that a block can be denied under the FCRA if a person received the goods or services that they're disputing. And this is really problematic for victims of coerced debt because, like a lot of my clients, for example, until they separated from their abuser, they, like, let's say, and this is the case, that they utilize that credit card, that credit, to obtain a good or service. So that good or service was obtained by that quote unquote household. But the survivor often didn't have access to it, didn't have possession of it, especially after separating. They didn't have that TV, that car, that a lot of times it was used for a separate business, things like that. And so that was a block, pun intended. It was a block to getting the block. And so it was also a petition for rulemaking was seeking clarity on that for purposes of victims of domestic violence, sexual assault, human trafficking, that elder abuse, foster youth, that provision would not apply if consent was not effective. So it was accepted, and they issued an advance notice of proposed rulemaking in January of 2025. I believe the comments were due March 2025, and we submitted comments along with the folks on this call and with other groups. And, it was on the rulemaking agenda, the spring rulemaking agenda, but right now the CFPB is, in upheaval, to say the least.
You're not holding your breath, I take it. Yeah, I guess this is the kind of thing, it'll get revived sometime in the future when there's different administration. It's not necessarily a dead letter. It's there. It's just doubtful anything's going to happen. Okay, I want to leave some time for Dan because I know he's anxious to provide an industry perspective on things. And Dan, as I indicated when I introduced you, you regularly advise financial institutions that are navigating evolving regulatory and compliance environments. And boy, this coerced debt thing certainly is evolving very rapidly, changing rapidly. It's a multi-state issue. It's not just New York. So what are, from the standpoint of creditors, servicers, and debt collectors, what are the most significant implications of the New York law?
Yeah, thanks, Alan. And I think I speak for the whole industry when I say we all agree coerced debt is a problem in the country, and that, as we've already talked about in this discussion, there are a lot of gaps for recourse for people who are survivors. And so, I think New York is a good example of really trying to get help for these people. And I saw a couple of questions just, helping the creditors too by giving them a private right of action against the abuser in cases of coerced debt. And also, I believe, gives the survivor that same private right of action if they, have already paid the debt. And so, those are good things to help the industry. One of the biggest implications of the New York law is identifying coerced debt, as we've kind of already talked about. There are no magic words to make their coerced debt claim. They could go into a branch and say, "It made me do it." And so the people who are on the front line talking to customers need to be able to identify coerced debt. They also need to be able to identify that this was a New York problem. If you're a national creditor and you have a national customer service line, you need to be able to say, when they say that, this is a New York customer who is making a claim of coerced debt, they need to send that notice to them regarding their rights under the New York law. So that's going to be a big undertaking for a lot of these people, making sure all of their frontline employees are trained and are able to identify so that they can begin the process of investigating a coerced debt claim.
So, Dan, if it involves a bank, let's say, and I don't think banks aren't exempt, I don't think. Everybody's covered. You go into a bank branch and you tell a teller, that's considered notice.
Right. I would say that that's notice of coerced debt that the bank has to, assuming they didn't provide the police report and the other whatever documentation they must provide, but they have to give that notice.
Yeah.
After that.
Yeah. So other than what you've already described, what other operational and compliance challenges does the law create?
Well, one is, it makes it makes it harder to investigate claims of coerced debt. And I'm not saying that they need, to do anything different. I think they're all very fair things, but like you can't contact the abuser. I think we all agree that's a good thing, but that also may make it harder to investigate a claim. You have to make sure that you're not using the other contact information that you have on file. You have to make sure you use the contact information that the survivor has given on their claim and no other contact information. That can be a big problem. That's going to be easy to mess up. And so creditors need to be aware of that. And then you also need to be aware of that you can't really share the information with other people. I think there's a very limited ability to share the information of the coerced debt claim. And that also can make it harder to investigate without that kind of information. And then the next thing is when you're looking to see if it's coerced debt, how do you figure out if there is an intimate relationship between the two parties? I think a lot of times it's easy if you're a parent-child or a married couple. But if they were dating, that's not something necessarily that a bank knows and could easily figure out, especially when you can't share information to other people who may know. So those are some other challenges I think we're going to see for creditors to comply with this law.
How should institutions handle claims of coercion while maintaining appropriate controls and documentation?
Yeah, the investigative process is a really big compliance challenge, as we've already said. And so, and then seeing the actual documents that are given. For instance, we represent a big national bank, and this was right before the original effective date was supposed to kick in. They got a claim of that certain credit card transactions were coerced debt. They submitted a police report, and so the police report didn't have their name on it. It had no one's name. And our understanding was that is normal in domestic violence situations. But, whenever you see a police report without a person's name, it's tough to figure out, is this police report actually from the cardholder, from the survivor? It's hard to figure out. It's hard to figure out if it's genuine when there's not a name. So those are all things that you have problems with. And so figuring out how to best navigate that, knowing that, there's a reason that someone's name isn't on these police reports. And so, protecting the survivor in this situation while also coming to the right answer on a coerced debt claim.
Right. What concerns might industry participants, Dan, have regarding potential abuse and unverifiable claims?
Yeah, the tools are a little bit limited when you're investigating coerced debt. And, just trying to figure out if there's an intimate relationship between the two parties. That can be a concern about, specific, if they say these specific transactions were coerced debt. Maybe, did one or two like credit card transactions slip through the cracks? You only look at the 4 different transactions they claim were coerced debt, or do you look at other similar transactions that you think were those coerced debt too? They were might have been at the same merchant. Things like that. Those can be real things that a creditor has to think about when figuring out whether these claims were verifiable and, whether there were other problems with the coerced debt claim.
How should institutions strike that right balance between being sensitive to the victims and risk management for the institution?
For clients that we've already talked about with coerced debt, everyone wants to be very conservative. No one wants to make headlines for denying a coerced debt claim for a survivor. And so, over right now they're being really conservative. I think over time, as they get more and more of these coerced debt claims and they investigate and understand what these claims look like, they'll be better at, identifying genuine claims and claims, that raise red flags. But also, as we've talked about, there's a private right of action for the creditor against the abuser. So, they still, even if there is coerced debt, it's not that, the bank is the one on the hook at the end of the day. They still have a claim to go recover the coerced debt from the person who probably should be paying it anyway.
Do you think that's really a practical thing for banks? I mean, the abuser probably, it's going to be hard. It might be hard to find or identify, find out where they are. And there's probably a very strong likelihood that the person's a deadbeat, that they're not going to be able to collect it. So I'm just wondering whether it's a remedy, but is it a real remedy that's going to provide recourse?
Yeah, I mean, I'm not a litigator. I'd be happy to defer to a litigator, but I don't think they're any less likely to be someone who can pay a debt than the survivor. And so I would start there. They may be harder to find, but I don't know. I feel like litigators can find people that they really want to.
Yeah. So final question, because we're getting at the end of our program. What would be your key recommendations for financial institutions that are impacted by this New York law? There's not a lot of time left. We're talking about a little over a month, but it sounds like there's a lot of work involved, right? What should they be doing?
Yeah, they should be figuring out how to comply. They should be really trying to figure out their compliance policies, procedures, and training to make sure that they know how to handle these before they start coming in.
Right.
The good thing is for creditors, they have a lot of investigative teams already, that can handle similar types of investigations. Like a fraud investigation probably looks a lot like a coerced debt claim. Where does this person normally spend? What dollar amounts do they normally spend at? And for transactions that don't, meet those criteria, are there other red flags? Those are the same things for fraud and coerced debt. So I think creditors already have a lot of people involved that can be retooled to also work on these. And now I think Professor Litwin at the start showed there could be a lot of coerced debt claims coming. I feel like there was a large number of people who were victims of coerced debt. So it could be a higher number than maybe people are expecting. So you need to be ready to handle these. And also,
the effective date is going to be September after the amendment. So 4 months, not one.
Oh,
I'm sorry.
It's been changed already?
Yeah. So when the amendments were signed in March, it's the effective date is 180 days after that. So we've got an amended version compared to December. I see a lot of questions about in the Q&A, so I just wanted to clarify that.
Yeah. What is the exact date? I'm sorry. I apologize for getting that wrong.
No.
Yes. 16th, and Westlaw got it wrong, so that may be why the confusion.
Yeah.
And one thing that I wanted to add, you were talking about you could have a lot of coerced debt claims. I just want to share, in Texas, the Texas Coalition on Coerced Debt received a grant to conduct a coerced debt pilot program to help victims obtain relief under our laws. And that was it was isolated to the Dallas-Fort Worth area where there's 8 million people. And over the course of a year, there were 111 referrals, around 6 to 7 referrals a month. Of those, 38% were identified as coerced debt possible, and direct services were only provided to 19 people. And the majority of these debts were less than $3,000. So out of 8 million people, only 19 utilized the legal relief available. So even though you're like, oh, it's only a small number of people, it was huge for these 19 people, but it was 19 out of 8 million. So I just wanted to set the stage on that too.
Yeah. So are you saying then, I know it's for the people affected by it, it's nothing bigger than the thing, but looked at from a macro standpoint, it's not, you don't think that big a problem? I don't mean to put words in your mouth, but
it's not that. The way I would say it is that the population that it impacts is smaller than the population writ large, but it's a big deal to that population.
Yeah, sure. Understood. So I take it, Dan, you got to change your written policies, written procedures, and that could vary from state to state. I mean, it's still, while there's more time to get all this done with respect to New York than I thought, it's the summer months, not a lot gets done. still requires a lot of work, for sure.
Absolutely. And, as everyone else has said, a lot of states are moving in this direction. So you need to, creditors need to stay on top of each individual law and each individual legal landscape, because they all might differ slightly, timelines, definitions, things like that. So you need to be aware of all of the moving parts here and try, the easiest way, if it all works out, is to have, one compliance policy anchored to the most conservative requirement so that you can comply in every state. But it may not happen. There may be some that are kind of at odds, and we'll just see how it all evolves.
Yep. Okay. Well, let me thank all of our panelists for providing just an outstanding and insightful discussion today about a subject that at least I didn't know a lot about before I started, doing some reading about it a couple of months ago. I think there are a few key takeaways that stand out to me. First, it's coerced debt is increasingly being recognized as a serious form of economic abuse that existing legal frameworks have not really addressed effectively. And second, New York's law represents really a groundbreaking development. While there are other states that have enacted coerced debt laws, I don't think any of them are as broad as the New York statute in terms of people who are going to be provided with remedies and in terms of its impact on the industry. And I would think the New York law would probably become a model for other states that are thinking of doing something. As today's discussion demonstrated, implementation will raise very important questions regarding evidentiary standards, operational procedures, compliance obligation, and consumer protections. Third, this is an area that's got to be watched very closely. We heard from Carla about already a dozen or so states that have enacted in one form or another statutory protections pertaining to coerced debt, and there are bills pending in a lot of other states. And this is an issue that is going to only grow. It's not going to diminish in size in terms of the activity of states. And I think there will be more activity at the federal level, maybe not so much during the remainder of the existing administration at the CFPB. Don't know about what the FTC thinks about all this. They've tended to be a lot more active than the CFPB. And finally, this is really the final point that I made a note of. Proactive planning is absolutely critical. And I'm now talking to industry folks. Financial institutions have got to be reviewing their policies, procedures, their training, their dispute resolution frameworks that they have. And they got to be doing that now to prepare for what could be an increasingly complex patchwork of state requirements. And although we didn't mention the word today during the presentation, arbitration, if you put it as a question of, what effect of this is an arbitration provision going to have, I would think it's going to be very difficult to use arbitration, particularly in states that invalidate the debt. Now, the question will be, will it be the arbitrator who decides that or the court that decides that? And, we'll have to see. That will have to play out.
To make sure you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights about the consumer finance industry. And if you have any questions or suggestions for the show, please email us at podcast, that's singular, at ballardspar.com. Stay tuned each Thursday for a new episode of our show. Thank you for listening and have a good day.